So hopefully you guys have watched the opening statement, and I wanted to go over a couple of things that you want to look at in the opening statement. This is actually from the American Bar Association website, which I'll put on the notes for today for Mr. Catch to share with you. But these are a couple of things that I want you to look at, and in particular decide for yourself whether or not you think the respective counsels for both Depp and Heard actually accomplish these things. So the first one we're not going to be able to talk about because we weren't able to witness the voir dire. That's not televised. But here's something that it's worth you looking at. Did the attorneys of record, and it looks like that Depp had two attorneys, two counsels, and then Heard had one, or maybe also two. It's a little difficult to tell. But did they establish credibility, right? Did they, with their opening statement, demonstrate their sincerity, their knowledge of the facts, their confidence or likability? Now, it is true that sometimes it is difficult to get jurors to like you if you're an attorney for a variety of reasons, but you don't want them to hate you. So sometimes it's better to be respected than liked, but in general, it's better to be both if you can do it. So were they able to be liked? Were they able to make someone, if you were on the jury, would you trust them? Okay. So that's one of the things you want to do in an opening argument. Tackle any unfavorable facts head on. So if there are unfavorable facts to tackle head on, were they able to do that? Were there bad facts about the client or weak aspects of their case that they tackle directly, right? You don't want to hear the bad stuff coming out of the other guys or the other side. You want to address it right away and soften it or explain it or somehow spin it in such a way that it doesn't come out quite so badly on your side, okay? Sometimes there are PowerPoints and whiteboards. I believe one side did have whiteboards, but try and give the jurors a feeling for what kinds of evidence are they going to see. What are the issues? What matters here, right? Because jury's attention span is about the same as a student's attention span, which is about 15 minutes if they're very, very bright and they're listening to something they're interested in. If one of those two things isn't true, particularly the interest part, it's about half that. So a roadmap sometimes gives the jurors a feeling for where pieces of evidence should be placed in the overall kind of map of evidence they're going to see. Okay. At the end, you do want to tell a story, right? A trial really is a story for the most part. It's not just a selection of facts and arguments. And a narrative is something that a jury will remember. And so often the roadmap is a way to fit the facts into the narrative. Okay. But you really do want to tell a story. A trial, in many ways, I've heard it described as a play where all the actors are present and your beginning and ending are more or less set out, but what happens in the middle is up to you as a trial attorney. So you do want to make it a story, and sometimes offering a roadmap helps that narrative. Okay. Don't present anything in an opening argument that's not going to be shown in evidence. Now, we haven't seen the entire trial yet. We'll hopefully watch some of it together, but it's important not to promise something that doesn't appear in evidence. Okay, so be careful. Sometimes you couch what your opposing counsel is going to argue, but you couch it from your own perspective. Okay, you try and really take the wind out of their sails if you can. Say the other side's going to say this, and here's why that's wrong. Okay. Good eye contact, right? So one of the things that's important, probably one of the most important skills you can learn in the real world is public speaking. And being an attorney, of course, is one of the places where people recognize it, although it's probably important everywhere. But making good eye contact, particularly in Western countries. We are a nation of people who believe the notion that if you can look someone in the eye, you're being sincere and believable. Now, there are other countries for which looking someone in the eye actually is considered to be bad manners. But in the United States, at least, making good eye contact matters quite a bit for how they see you and how comfortable they are with your authority and your trustworthiness. Okay? Note it's not a time to argue. It's not a time to be shrill. It's not a time to be excited. It's not a time to be angry. If a jury gets the impression that you are any of those things early on, it can turn them off. It can make them feel like, oh, this person is not trustworthy. Right? I can't trust what they're going to say because they're a little too dramatic. Okay. I'm a pacer. You guys have already seen that with me in the classroom. I like to pace, and sometimes I had to temper that when I was trying cases, not to walk in places that was difficult for them to see or hear. And sometimes I had judges tell me, on occasion, a judge from Eastern District Court who will go unnamed actually said, you can't walk that close to the jury, you can't walk that close to me, you can't walk that close to the court reporter. And so I just sort of had to pace in a very small space. And sometimes I have to stand behind the lectern for some judges, which is really tough for someone like me. So keep that energy contained. If you are someone who has sort of nervous tics, you play with your hands, or you play with pens, or you do things like that, things you have to be aware of how they come off. Okay. Know how your argument's going to close when you open. Okay. The closing argument is one of the first things you actually draft and complete before you start anything, because this is what you are trying to direct the trial towards. This is sort of the climax. This is the ultimate outcome. And so you need to understand what your closing argument is before the trial even begins. So one of the things to think about when you listen to these opening arguments, can you get a feel for what the closing argument is going to be? Can you get a feel for where they're trying to direct their evidence and kind of direct how the trial is going to go? Engage the jurors as much as possible. Although, again, the thing about this is everyone has their own style, and you have to find out what your own style is. For some people, it's low voice, quiet, but sincere. For others, it's more bombastic, more dynamic. Everyone's got their own style in speaking, and likewise in trial law. So one of the things to look at is the difference in style, right? These are three attorneys who are quite different in style, both in the way they address the jury, the way they move, the way they speak, the way they act. Which do you feel was the most effective? Which approach do you think made the most sense given what they were saying and what they were trying to argue? Did the fact that they were male or female matter, right? That can have an impact on how juries see someone. Does it matter if someone who is male or female makes a certain kind of argument? Sometimes it does, okay? If the evidence is unclear or uncommon in sort of popular culture variants, you're going to help the jury understand the evidence. Ultimately, you'll be arguing for getting jury instructions before them, but prior to that, you want them to understand what's going on, and you want them to feel that you are a reliable guide to what's going on. If they feel you're a pure advocate first and foremost, then it can be more difficult for them to trust you. And you want the jury to believe that you are an advocate who, in some sense, is reliable and can say, this is what's going to happen. Okay? So I wanted to go over those things with you just to give you a feel for a way to assess the opening arguments and take a look at them. And in particular, I want you guys to as groups to get together and kind of talk about what things went right and wrong. And as groups, start preparing presentations of maybe 3 to 5 minutes that maybe you'll do during next class. Just saying what you would have done, what you thought they did a good job at, what you think they didn't do as good a job as you would have liked, and what you might have done differently if you were doing opening argument for either side. You get to choose which side your group is arguing for or against. Okay? All right. So I hope that's clear. If there's any questions, Mr. Catch has my information to get a hold of me. You all have my email, and I will, I believe I'm seeing this, some of you I'm seeing on Friday, and some of you I'm seeing next Friday. But next week I'll see everybody. So this week I'm only seeing one set. I think I'm seeing the B day on Friday. And the following week I'm seeing A and B day every day. All right, so hang in there. One more week. I'm thinking of you. And I hope the rest of your day goes well, okay? Take care.